Hello and welcome to today's ResNexus webinar, Practical Privacy, What You Need to Know About GDPR, CCPA, and Emerging Regulations. Today's webinar is hosted and presented by Lisa Soto. Lisa chairs the Huntington's top-ranked global privacy and cybersecurity practice. She's well recognized in the field of privacy and cybersecurity, and Lisa was named to the National Law Journal's The 100 Most Influential Lawyers in America list. Chambers and Partners rated Huntington as a star individual for privacy and data security in its Chambers USA guides, and the Legal 500 United States ranked the firm in Tier 1 for cybercrime and privacy and data security. She was also profiled as the Queen of Breach by Super Lawyers. Welcome, Lisa.
Thank you very much. I'll take it from you from here. Thank you so much. So I'm going to talk about the privacy environment today globally, focusing on the US, but really all over the world. And it is an exceptionally active environment right now. It's hard to keep up with what's happening, even for those of us who are dealing with this 24/7. It's extremely difficult for those who have other jobs as well. The area really went from being an area of Byzantine regulatory compliance to one of deep societal relevance. We read about this issue on the front page routinely now. So we are very focused as a society on the issue of data privacy. So I'm going to spend the next hour or so going through essentially a global tour of privacy developments around the world. So I'll hit some global concepts. We'll talk about what's happening in the in the US, then the EU, and we'll turn to other global regimes as well. Okay. We are certainly, of course, living in the information age now. It is the digital era, and data has been referred to as the new oil because it really does fuel the economy. We are grappling with these issues all over the world. And I'll just note that every first world country other than the United States has a comprehensive data protection law in place. We do not. We are still struggling with that at the federal level, while we have states actually filling those gaps. We have also seen that enforcement has increased in a big way over the last few years. And I just want to note that the approach globally to data protection or privacy, and by the way, data protection and data privacy are the same thing. The lexicon is different depending on where in the world you are and who's talking about it, but it's the same thing. The approach to data protection really is very much based in the country's historical experience. For example, in the EU, there is constant reference when thinking about data protection issues to the Holocaust, the Nazi regime, and the use of data in that regime to persecute people. In this country, we think about the use of data and think about marketing people to death. So it's a very, very different regime. In the US, we have a consumer protection bent around data protection and data, the use of data. Overseas, in many countries, data protection is viewed as a fundamental human right. And we see those words in the preamble of legislation outside the United States. So how should we generally think about what the world thinks about data protection laws? So what you see here, this is a little bit dated, but it's a good characterization of what the world thinks of us in particular. So in blue, what we see are countries with comprehensive privacy laws in place. In red, pending laws, and some of these have now been pushed through. And in white, no laws at all. And of course, what is glaring here is the United States. That's not true, but what we have in the United States is actually a very confusing regime, and we'll talk about why it's confusing in just a minute. But we have a fragmented regime that is not comprehensive at the federal level. So we are viewed by the rest of the world in many cases as really not having a data protection regime, a data privacy regime in place, because we regulate in this fragmented way. So thinking about the general principles that are the bedrock of really every data protection law around the world, we see principles such as lawful, fair, and transparent processing of data. Transparent, we are inundated with privacy notices. That's what transparency means. Collection and purpose limitation essentially means that you are collecting only what you need to serve the purpose for which you're collecting the data. And then if you skip down a couple of bullet points, you see data minimization, and you're keeping it only as long as you need it to serve the purpose of the data collection. Many laws, most data protection laws, provide individuals with rights: the right to access the data that the company has about you, the right to delete that data, the right to correct it if it's wrong. So there are individual rights built in. Data integrity is ensuring that data is accurate, and that's particularly important in, for example, the consumer reporting context, because if your consumer reports are not accurate, you could be denied credit, for example. You could be denied the right to fly. So data integrity is actually a very important principle. In all of these laws, we see clauses that deal with service providers and how to manage service providers in a way to essentially ensure, at least contractually, that they have appropriate protections in place with respect to personal data. And that leads right into the company having appropriate security in place to protect data, along with redress mechanisms if somebody thinks that they have been done wrong based on their data. There needs to be a way to approach the company and get redress, and then of course enforce the rules within the company and outside the company. So let's talk about, and the next one, let's talk about what's happening in the US. So earlier I said we've got this very fragmented approach in the US. It is a patchwork quilt, really, of laws, and it's very, very difficult, I think, for people overseas to understand, difficult for people in this country to understand who are not steeped in it every day. We have the consumer protection requirements of the Federal Trade Commission Act that prohibits unfair or deceptive trade practices. And it's that unfairness and deception bedrock that has formed the basis for many of the privacy enforcement actions in this country from a government enforcement perspective. The Gramm-Leach-Bliley Act is the privacy regime that applies to financial institutions. HIPAA, you've all gotten HIPAA notices from your doctors and hospitals and health plans. That is in the healthcare sector. The Fair Credit Reporting Act was really not thought of at the time it was passed as a privacy law, but it really is, and it affects consumer reporting agencies and those who get reports from consumer reporting agencies, like background screening, and when you apply, of course, for credit, you get a consumer reporting agency report. CAN-SPAM it's very unusual globally in that it is an opt-out regime for commercial email, meaning you have one bite at the apple to send somebody a commercial email targeting them or advertising to them, and you have to provide an opt-out opportunity. Most of the rest of the world, where they have a spam-related law, have an opt-in regime. You have to opt in to receive these sorts of emails. So we're a bit of an outlier there, but we do have the CAN-SPAM Act. And then we have some really sector-specific laws. The Video Privacy Protection Act that impacts video rental records, the Driver's Privacy Protection Act that impacts state DMVs, telephone, and then the Children's Online Privacy Protection Act, which may in fact get revamped. Even in this session of Congress, we've been hearing, even in the lame duck session, we've been hearing something about that. Children's data, so this is for kids under the age of 13. And the very first Privacy Act, actually globally, was the Privacy Act of 1974. And for those of us who are of a certain age, we remember Watergate. Watergate was in 1974, and this was a reaction to Watergate, the Privacy Act of 1974. It affects only the federal government. At the state level, so states are often considered the incubators for federal laws, so they're a test laboratory, if you will. And we now have omnibus comprehensive privacy laws in 5 states: California, Connecticut, Colorado, Utah, and Virginia. And California is in effect right now. I'll talk quite a bit about that. Virginia, the effective date is January 1, and then the other 3 laws become effective during various times in 2023. So those are very important laws, and they really changed the landscape in the United States. And federal bills are really now patterned after these laws. There are also 3 states with comprehensive biometric privacy laws regulating the use of biometric data, fingerprints, facial template scans, and retinal scans, corneal scans, and the like. So that's Illinois, Texas, and Washington. Illinois has a private right of action, and some of those settlements have been huge. So that's one to really watch out for if you're capturing any biometric data. And then some municipalities also have biometrics laws: Baltimore, New York City, and Portland. There are laws on website privacy notices. There are state-specific health laws. There are social security number use restrictions. You can see down the line, there are so many different privacy laws in the United States that it really is very hard to keep track. And I just want to skip down to that very last one. There are data security laws in the states, and those are really tricky because data generally is not confined to a single state, but there could be security requirements that apply to data as it sits in a single state. And of course, the breach notification laws, there's just about nobody in the United States today who has not received a breach notification letter. And what those laws require is that to the extent you have, there's a compromise of certain sensitive personal information by an unauthorized party, you need to let the affected individuals know about it. So those are very influential and important laws. So as I said, there has been a really significant shift over the last couple of years at the state level with respect to comprehensive privacy laws. And what we see here is a detailed timeline, which I'm not going to go through, but I just want to pinpoint some particular dates. So it was just around it was around 2018 that it was in 2018 that we had our first comprehensive privacy law come into being, and that was in California. And that became effective, by the way, January 1, 2020, right before COVID. And then during COVID, the drafters of that law actually didn't really like how it came out, and so they decided they were going to push through a ballot initiative that would amend that law. And they bought, my understanding is they bought 300,000 pens, and they got enough signatures to put a ballot initiative on the ballot, and the voters voted in favor. So we have now a comprehensive amendment to the California Consumer Privacy Act, known as the California Privacy Rights Act, CPRA, and that becomes effective January 1. So in 16 days, 17 days. That law becomes effective. And then following the California initiative, we saw Virginia come into play as well, and they passed a law in early-ish 2021. Then Colorado did, then Utah did, and then Connecticut did. So here we are now with 5 states with comprehensive privacy laws. So the California Consumer Privacy Act really changed the landscape. It is the first general US privacy law, meaning it doesn't just apply to health data or to financial data or to video rental records, but instead applies to every human who is a resident of California, period. And what it does is it grants California consumers, humans, really natural persons, it grants them certain rights over their personal information. And I just want to note here that consumers in California, as of January 1, that will include HR individuals as well as B2B data. So it's a very comprehensive term. There are rights that people have now. They have the right to access their own data, to delete it, and to opt out of the sale of data. Sale is very broadly defined as any kind of cross-context behavioral advertising that's done, or any sharing of data with a third party for that third party's own purposes, where something of value, whether it's money or something else of value like data analytics, is returned in exchange for the data. You need to provide very specific privacy policies. The content is specifically prescribed. You need to contractually restrict the activities of certain parties like service providers. You need to train relevant personnel. And as I said, the deadline was January 1, 2020. Enforcement began on July 1. And actually, we just saw a couple of months ago our first enforcement action. It was Sephora, and they paid $1 million fine for a violation of the CCPA. There is also a limited private right of action that has been tested over the last couple of years, still testing the waters on that. So, as I mentioned, the California Consumer Privacy Act was amended by a ballot initiative, and voters voted it in. And what it does is it provides new consumer rights. There's now a right to correct one's data if you're a California resident. There is the right to opt out of the use of sensitive data if that data is used to infer characteristics about an individual. There is a right to opt out of the sharing of data for cross-context behavioral advertising as well. As I mentioned, HR and B2B data now are in the mix as of January 1 coming up. And there is a new agency that's been established in California called the California Privacy Protection Agency. Right now, the Attorney General is still enforcing, but that enforcement is going to move over to the CCPA at some point, and they will start enforcing this law. So other states, the other four, and this deck is specifically designed to put these laws into two buckets. The first bucket is California, and it stands alone, and it's really different from the other four laws. And the other bucket are Colorado, Connecticut, Utah, and Virginia. Because those laws are actually very similar to each other, not identical, and there are some very important differences, like Colorado applies to not-for-profits as well, the others don't. There are some other important differences, but they're very similar to each other. So the applicability of these laws is actually much narrower than that in California. So there is no application to HR data for these laws. There's no application to B2B data for these laws. And in order for these laws to apply, you need to have revenues of, you have to be processing the personal data of over 100,000 residents of these states. And that's essentially the test for a lot of our clients is do we have 100,000 Virginia residents in our systems, 100,000 Colorado residents, Utah, et cetera. So there's a lot of language here on this slide, but that's a really good way to think about it. In California, by the way, if you have 25 million in revenue, you're subject, and that's globally. That's not just in California. 25 million in revenue globally puts you into the mix for California if you have any California individuals' data in your system, even one. So there are some very, very significant exemptions in these other four laws. For example, any financial institution that's subject to the Gramm-Leach-Bliley Act is out. In California, only data subject to the Gramm-Leach-Bliley Act is out. That's true of HIPAA as well. So if you have HIPAA covered data in California, that data is out of the mix because you're covered by HIPAA, but the entity is still subject to the California law. That's not true in the other 4 states. And then the other thing I just want to point out is HR and B2B data are excluded from these other 4 laws, which is a very important difference. So some of the key concepts that I just want to hit on with respect to these 4 laws, and we've seen these key concepts over and over and over in data protection laws. So the first is privacy notices. You need to have a privacy notice that addresses the information that you collect, how you use it, to whom you disclose it, what security measures are applied. So there are various requirements in the state laws as to what needs to go into a privacy notice. As I said, the rights are also a bedrock of so many data protection laws around the world, including these 4 states, as well as California. You have a right to access the data that a business holds about you. You have a right of portability, meaning you can take your data and move it from one entity to another. And an example of that we're really seeing as a live example, although these laws are not in place yet, is Twitter. A lot of folks are moving off of Twitter and onto other platforms. When these laws are in place, there will be a requirement of portability. That is true. That's coming in January, also for California and Virginia, and then later in the year for other states. There is a right to correct your data. If data is inaccurate, then I have a right to correct it if you're holding inaccurate data about me. I also have a right to ask you to delete my data. There are some exceptions there, so it's not an overarching right, but there is a right to ask for deletion, and you have to think about whether or not you will grant that right. There's also a right to opt out of targeted advertising, of profiling, and for sensitive data, it's an opt-in. So if you're capturing sensitive data, like health information, you need to offer an opt-in opportunity before you can capture that data. And of course, you need mechanisms, tools, to be able to process these requests. With respect to vendors, service providers, you need to have a contract in place that restricts the activities of service providers in connection with the use of data. And these are required provisions. This is not optional. So this is true in California as well as the other 4 states. Let's talk a little bit about enforcement. So these 4 laws are enforceable by state attorneys general only. There is no private right of action in these laws, and as you know, that could be a very, very costly thing to be subject to private civil lawsuits. California does have a limited private right of action. It's really intended for security breaches. So to the extent there is not reasonable security in place to protect data and you have a breach, then you could be sued in a private action under the CCPA and CPRA. There is a cure period under all of these laws of 30 days. And actually the Colorado law provides a 60-day cure period. So there is, you will get notice that you may have violated one of these statutory provisions. And then you have some period to fix it. I'll just note that the California cure period, which is 30 days right now, actually which becomes discretionary for the agency as of January 1. So it doesn't necessarily exist. The fines are pretty costly. So as you can see here, it's for some of these states, $7,500 per violation, for example, and query what a violation means. Is it one event? Is it per person, per day? And we don't know yet. There's no interpretation of these laws. So these can be actually pretty costly to violate. So ad tech. This is a really important area, and it's changing like crazy, very, very quickly. So these new privacy laws give consumers the right to limit the processing of their data in the context of online advertising. So as I mentioned, there's a right to opt out of the sale of data and the sharing of data for behavioral advertising purposes, and also a right to limit the use of sensitive personal information, whether through opt-in or opt-out opportunities. So very significant statutory restraints. And then the private sector has also taken measures to allow for choices, and particularly Apple has put in place the app tracking transparency framework that requires apps to get opt-in consent in order to be able to track users. And that's a very important change for Apple. Google Chrome has said that they are going to deprecate cookies within the next year or two. As the deadline has been pushed back a bit, but they are going to deprecate third-party cookies as we know them. And of course, Congress cares a lot about ad tech, as do private plaintiffs, and we've seen a ton of litigation around tracking online. So this just gives you a sense of the fact that there are many states now that, and this is a little bit old as well, and of course we're in a lame duck Congress right now, but a number of states have actually contemplated privacy laws. Some have passed, some have not. So we're leading to a place where we're going to have this incredibly patchy regime across the United States, which of course is not terribly useful when we're talking about personal data that can sit in systems in 50 different states all at the same time. So it's actually very hard to have different laws apply to the very same data set. But we certainly have seen an uptick in state activity, and we're hoping there's going to be some federal activity. So where are we on the regulatory side in the United States? Section 5 of the FTC Act, as I mentioned earlier, prohibits unfair or deceptive trade practices, and this is the provision that the vast majority of privacy and data security cases are brought under in the United States, where there's government enforcement. The FTC is very, very active right now, and we see a real activist FTC at the moment. So we're watching them carefully. They've put out a set of proposed rules that could really change the landscape very significantly. There have been some huge settlements. I'll just mention Facebook's settlement of $5 billion with a B dollars, and this was over allegations that Facebook violated its 2012 consent order, and the complaint stems from the Cambridge Analytica case where Facebook was accused of harvesting user data of up to 87 million Facebook users for political purposes. So everybody remembers Cambridge Analytica, and it's really the line in the sand, as far as I'm concerned, in the United States, where we as a society started to really think hard about use of our data. Just to mention one other, Twitter paid $150 million fine, and this was a year or so ago, where they were using contact information that was obtained for security purposes for targeted advertising. So there have been some pretty hefty fines. I'll also just note that the SEC is very active in this space, and they've just put out, but a few months ago, put out rules, proposed rules for cybersecurity disclosures, and they would require, and we'll know probably Q1 whether these are going to go through, but that they would require the reporting of breaches in 8K forms within 4 business days. So that's a very, very aggressive time deadline. So just to give a quick summary here, the US really is out of step with global requirements. We are not in line having this patchwork quilt of a regime and not having a comprehensive privacy law at the federal level. We know that Congress is very well aware of this issue, and There are very few bipartisan issues these days, but this is one of them. So the devil is in the details, of course, but there's no question that this is a bipartisan issue. And I think having a split Congress actually may make it ripe for congressional action. So we'll see, because there may just be more willingness to compromise where there wasn't before. Of course, consumers are very well aware now of their data privacy rights, and certainly privacy overall has reached very high on the radar screen, particularly with the Dobbs decision. And then data security, we're seeing breaches, and for every day is not even close to describing it right, which is probably 10 or 15 times a day. So I think we are going to see over the next couple of years a comprehensive privacy law, and we'll see if there's going to be another agency that is put at the helm. But the FTC right now, the Federal Trade Commission, is very much the agency in charge of privacy in the United States, with help from other agencies as well. All right, let's leave the US and move to the EU. So we have had in Europe a very robust regime around data protection since 1995. In 1995, the EU Data Protection Directive came into being, and that directive was then passed into member state law in what was the 28 member states of the EU when the UK was part of the EU, and that Data Protection Directive, which really came about in the mainframe era, was then replaced and modernized by the General Data Protection Regulation. Regulation means it's in effect for all the member states without having to be enacted into member state law. So the regulation came into being it was effective in May of 2018. And it is a comprehensive data protection law that reaches across the member states. That's 27 member states now, plus the UK has enacted the same law as the UK GDPR. There are also other laws, so we can't forget about other sector-specific laws. For example, the e-privacy directive regulates how trackers, cookies, and other trackers are used on websites and apps. And then we have the Network and Information Security Directive as well with respect to cybersecurity. And I'll just note that the GDPR really is now the iconic global rule, if you will, the law of the land, because many of the data protection laws around the world have either amended their laws to look more like the GDPR or have passed laws initially that looked very much like the GDPR. So it is exceptionally influential globally. So it's a very important law to get your arms around. Some of the basic concepts in the GDPR. So I'm just going to quickly touch on these. So first of all, from a scope perspective, the GDPR applies to all processing of personal data. So anything you do with data, including storing it, deleting it, collecting it, disclosing it, anything you do with data is considered processing. And personal data is any information relating to an identified or identifiable human. And some examples there, name alone is personal data, and the GDPR would apply. And then you get into other data like device level data, IP address, for example, that also is personal data. And then there are special rules around sensitive personal data, and here's what sensitive personal data is. It's race or ethnicity, political opinions, religious or philosophical beliefs, trade union memberships, genetic biometric data, sex life or health, sexual orientation, and criminal convictions. So that's what sensitive personal data is, and you can't process it without opt-in consent in the EU. Two key concepts, that of data controller and data processor. And you can think of this in US terms as the entity that essentially controls the data, the business, if you will, versus the service provider. A data processor is essentially a service provider and takes instruction from the data controller and must abide by the instructions of the data controller with respect to its use of data. There are required provisions in the contract with the data processor, and the idea is to contractually bind the processor so the processor can't use data in ways that are not understood, accepted, and instructed by the data controller. So some of the basic principles, and these are deliberately very similar to the principles that you saw on the first slide, because these are the principles that are found in most data protection laws all over the world. Privacy notices, transparency, let people know what you're doing with data, and then do what you say you're going to do with data. So say what you do and do what you say. Limit the purpose for which you use data to that for which you collected it. Make sure you're not collecting more than you need to serve that purpose. That's the proportionality principle. And then get rid of it securely when you don't need it anymore to serve that purpose. Make sure data is accurate and up to date, particularly if that data is used to make significant decisions about individuals, like credit reporting data. And then store the data only for a limited time. Make sure it's kept in a confidential manner. And organizations need to be accountable. They need to demonstrate that they are processing data in compliance with these principles. And then the general principle of lawfulness, that you need to have essentially a legal basis to process data in the first place. And that's a GDPR concept. As I said, we see very significant rules around managing vendors. You need to have contract provisions in place. That is not optional. It's a requirement that you have certain contract provisions in place to bind your vendors to use data in the way that you are dictating. There are data subject rights pursuant to the GDPR. These are essentially the rights that are granted: the right to access your data, to correct the data, that's the right of rectification, to delete your data, the right to be forgotten, colloquially. You can ask for certain restrictions around data processing, portability of data. You can object to certain processing, and then to the extent there are automated decisions made, there are rights with respect to those decisions as well. I want to touch quickly on data transfers. This is an absolute nightmare of an issue, and we've seen a ton of change in the last couple of years with respect to data transfers in the EU. To the extent you are transferring personal data from an EU member state to a country that is not considered by the European Commission to have, quote, adequate data protection laws in place, then you need to jump through hoops to be able to transfer data. And those hoops usually are in the form of a specific type of contract known as standard contractual clauses, or SCCs. And there are some other ways that you can transfer data as well. But essentially, you can't transfer personal data out of the EU or access it in a country outside the EU that is not considered to have adequate data protection laws unless you have certain protections in place, and the protections to put in place are very specific, the ones listed here. So there has been really a ton of regulatory action since the GDPR became applicable. There was an initial period when data protection authorities, that's what DPA stands for, data protection authorities were getting acquainted with the new law. They were understanding their new powers, and after that initial period, we've seen a significant increase in regulatory action over the past few years. There's been a lot of regulatory guidance that has come out as well, and we've seen fines that exceed well over 1.5 billion euros. So some of these are very significant fines. For example, Amazon, there was a fine imposed on Amazon Europe for 746 million euros, as an example. There have been some in the hospitality sector as well. Many of those have actually been imposed as a result of video surveillance, so just something to look out for. Let's go to the rest of the world. So there have been really very significant changes over the last few years across the world with respect to data protection, and as I said, very much influenced by the GDPR. I'll add one to this list, and that is Indonesia, which is in the last few weeks. Indonesia passed a comprehensive data protection law. Brazil did a few years ago. That's very influential, and we're now starting to see that enforcement and regulatory activity ramp up there. Canada has had a data protection law in place for many years. It's one of the oldest regimes, but it's being revamped to more closely conform to the GDPR. Thailand also has a new data protection law. Japan's very much existing law, long existing law, also has been revised recently to conform to the GDPR. China has a new data protection law, the PIPL. Very influential, very important. China's a huge economy, of course, and so the data protection law there is going to have very significant ramifications. It's new. It hasn't been around for very long, and we're just starting to feel our oats with respect to the Chinese data protection law. So we have this patchwork of laws around the world, and it is really hard to come up with a conforming framework for managing privacy globally. So it is necessary to have programs that are essentially based on the principles and then tinkering as necessary in local jurisdictions with the various programs in the different countries all over the world. We see this lack of uniformity in the United States, of course, where we have these state laws, and then we hope that there will be a federal law that will preempt all of these state laws. But certainly we are seeing that data protection, data privacy, data security are priorities for both at the federal level in Congress and in the federal regulatory agencies, as well as at the state and local levels as well. So it is critical to take a strategic approach to this area. It's critical to think about consumer expectations, because you can really blow it if you are thinking about using data in a way that makes people uncomfortable, and that can lead to, of course, front page news. And then the regulatory standards all over the world are really changing dramatically. So I will stop there.
Thank you so much, Lisa. At this time, I'll take over. And again, if you have any questions for her, I know it was a lot of information and great information. We really appreciate it to understand that landscape. While you're thinking of questions, I'll go ahead and just do a typical review. If you want to see this webinar once it's posted, or past webinars that ResNexus have done, the easiest way is to go to our homepage and scroll down to the bottom of the homepage. And at the bottom, you'll see a webinars section. And if you click on view webinar, it will take you to our webinars page, where you can scroll down and see any past webinar, including this one on practical privacy. In addition, I wanted to let you know that if you have any questions about the ResNexus property management system, you can always go to support and click on that on your settings page, and it will take you there. One other thing that I wanted to say that probably will be coming in an announcement at a future date, but Lisa talked about the CCPA and the ability to remove data on behest of the guest. ResNexus has had that for probably 2 years now, because we knew that the CCPA was coming out, and that was a major factor of that. So if you have questions about how to remove that data, if a guest requests that, feel free to reach out to your red carpet professional or call general support, and they'll teach you how to do that. Again, if you have any questions, or if you're not currently a ResNexus subscriber but would like to learn more, please feel free to contact our sales line. And with that, we'll go ahead and go to questions for Lisa. Lisa, one of the questions that came in is, on the privacy law that you talked about, how companies like Google are getting rid of cookies. How does that affect, say, the individual hotel or places of accommodation that do Google ads? Are they liable, or what's their risk on placing an ad that uses that data if a law comes down, or if it violates the CCPA? Is that on Google, or is that on the individual property running the ad?
So if you have a website and you are allowing trackers like cookies for advertising purposes, say, onto your website, and you are getting back something like analytics or enhanced advertising ability in return for making the user data available on your website to that the entity that placed the cookie, that's considered a sale of data in California, and therefore you need to provide an opt-out opportunity. So if you don't provide an opt-out opportunity and you allow that third party to capture the data, and if it's considered a sale in California, then it's on you, and that's where enforcement is. Now, the bigger picture is, with the deprecation of cookies generally on Chrome, there is going to be less third-party data available because cookies will not be there. So you can't buy data, for example, or there'll be less of it, and it'll be less reliable because there will be less of it. So first-party data is going to become that much more important, and contextual advertising is, remember, back a decade ago, more contextual advertising was important, and it's going to really gain in importance again.
Okay. And then another question was, California, you mentioned that it was 25 million, which is that over the lifetime or of revenue, or just annual?
25 million in annual revenues globally.
Okay.
Yep.
And then another question we have is, one person commented, there's definitely, as more and more states come online, and is there a good resource where they can find out the privacy information, like all in one? What's their responsibility to do so, kind of thing? Like how do they keep up?
Oh, it's so hard. I sympathize. It's we're struggling even, and we are doing this 24/7. There's so much going on. I would suggest that you subscribe to our blog, huntingprivacyblog.com. We are posting on these issues sometimes 2, 3, 4 times a week. So if there's something new, you can scan the headline, and if it's not applicable to you, it'll take you a nanosecond to scan it, and then you delete it. But if it is applicable to you, there'll be a summary there, so you can take a look and see what needs to be done.
Someone asked, can you clarify what you mean by private action? Does that mean that my property can't be sued by an individual? They just wanted to make sure.
Correct. So a private right of action allows individuals to sue, not only individuals, but also class action lawsuits, where groups of individuals sue, and those are very expensive, obviously. So we are hoping, for example, in a federal law, that there won't be a private right of action, a right of individuals to sue, and enforcement would be limited only to government agencies that could bring enforcement actions.
Another question that I had is there a privacy notice template that you recommend, or a resource to find that people should put on their website?
No, I don't have one to recommend, because the tricky thing about privacy notices is that they need to, A, comply with legal requirements, and it really depends on which law applies to you, and that's not something you can get from a template. And B, it must reflect your information practices And if it doesn't, then you're subject to that the FTC's deceptive trade practice rule, because if you say, for example, something about what you're doing with data, like we don't disclose data to anybody, and in fact you are selling data, then that could be considered a deceptive trade practice. So templates are very tough in this area because the privacy notices must reflect your privacy practices.
Mm. And then I have a property that says I have a lot of guests that come from Europe. What happens if they send like a spam email to a generalized area in Europe, say that they were targeting a city or something in Europe? What does that mean? Because their laws and opt-in, are they allowed to send an email only if they have prior contact? Like how does that work? I've gotten that from other businesses too, where they're like, well, no one knows about me, so it's like the first one. I know it's a very United States view of things, like you mentioned at the earlier, but can you take us through that scenario?
Sure, it is a very US-centric thing to think I have one bite at the apple. I can send one email, and then if somebody wants to opt out, then I won't send any more. That is not true in most other jurisdictions. Canada has a very strict regime, for example, in this context, in the context of marketing emails. For Europe, if you are subject to the GDPR, and that's not going to be everybody, so not everybody with European customers is actually subject to the jurisdiction of the GDPR. That's a pretty lengthy analysis to do. But if you're subject to the GDPR, then you need to be careful about sending these marketing emails. And very much part of the mix is the e-privacy directive. And that's going to be a country by country implementation, because remember, regulations are pan-European, but directives are member state specific implementations of the directive. So it's tricky with respect to sending an email to European individuals, but you're really only going to be subject to enforcement if you're subject to those requirements, and you may not be if you're a US only entity. If you're targeting goods or services to Europeans, then yes, you would be subject to the GDPR. So there are it's a lengthier analysis, but it's definitely something to watch out for.
Someone just asked on Canada, what's the most common violation and fine that a place of accommodation would experience, like a private place of accommodation? Do you know?
Yeah, I don't really know. I'm not a Canadian lawyer, but there's an overarching privacy law in Canada known as PIPEDA, P-I-P-E-D-A, and that applies to consumers in Canada. So you have to be careful. The same principles apply that I've mentioned, notice and choice and rights. All of these are built into PIPEDA as well. So it's a very stringent law. And then there's CASL, which is their spam law, much more stringent than CAN-SPAM in the United States.
Okay. A lot of times what we recommend at ResNext that we have is when they collect guest data at the start, they have the ability to have it opt in or opt out. And so they do that. Is that enough of a notification where they can just say, don't email market me, or does there need to be more?
It depends on the jurisdiction, but yeah, there's specific language that needs to be included. So it's not just an opt-in or opt-out. However, in lieu of complying with all of the different requirements globally, the best practice is just get an opt-in and make sure that you're also providing appropriate notice so that I know what I'm agreeing to. Have a reasonably fulsome notice that says this is what you're agreeing to, yes or no, and don't have a pre-checked box. If you have a pre-ticked box, that's not considered to be appropriate opt-in consent.
On the, you mentioned another question was that there might be probably in the next couple of years or so, a federal data protection. Do you see like that mostly leaving smaller businesses alone, or, you know, having a threshold kind of similar to what's in, for example, in the ADA Title III, I think it's 5 rooms or less, you know, and the person lives on site, they don't necessarily have to do some of the physical aspects of it.
Good question, and we don't know because remember there is not right now a proposal. Well, there is a proposal that was on the table, but there's almost no chance that it'll pass in the lame duck session, which is now till the end of the year, and then you know, then we start all over again, and we'll see what's going to be introduced. So we can't answer that question, but certainly something to keep an eye out for. And there usually are exemptions or thresholds for smaller businesses.
And then I think that's most of the questions, but I wanted to end with one of my own, which is, you mentioned that CCPA was tested on a private right of action. What are you seeing? Was that just mostly in regards to data breach?
Yeah, it's a mix actually. There's been a lot of sort of pushing the envelope by plaintiffs' lawyers who are trying to see whether they can actually expand the ability to bring a civil lawsuit for alleged violations of the privacy sections, which you can't, but still it's very expensive to defend the lawsuit and have it dismissed. It still costs quite a bit. And then on the security side, yes, we are certainly seeing actions by private lawyers who are bringing claims where there have been security breaches or allegations of security issues.
And then I'm just checking to see if there's any more questions. If they do, I guess another one that I would ask is if they do get a notice of violation from an individual, like I said, most of it's the AG or department from the state. So at this point, it's usually larger scale businesses that are being targeted, or would a mid-size hotelier ever get a notice of data breach, and what should they do if they did?
Oh, I would definitely not rule it out. I think there's every possibility of it. If you do get a notice, a 30-day notice, you should work quickly to fix the issue that was identified. Probably need counsel to do that, but you know, the good news is you get 30 days before they would even think about bringing an enforcement action. So use that 30 days and fix the issue.
So at least they do give you a right to cure, which is, I know in our experience with ADA is something that people are looking for, because that's kind of an iffy place there on what the time frame is. Awesome. Well, thank you again. It looks like that wraps up our webinar for today. As far as questions, we really appreciate your time, Lisa, and all the knowledge that you shared with us today.
My pleasure. Thank you very much for having me.
All right. Have a great one.
You too.